Welcome to Guns, Guns, Gear, and Guns with Gary Gunderson. I am Gary Gunderson. The Supreme Court heard oral arguments this week about the ban on bump stocks, wherein the government is arguing that, though the statute says by a single function of the trigger, they want to interpret that to mean things other than the trigger, or redefining what function means. I swear most of the arguments revolve around this, but there are some real gems in here, so here are the highlights.
So my friend says the trigger moves back and forth every time a shot is fired. Our view is that those subsequent movements of the trigger aren't functions of the trigger.
So even though the trigger is pulled for each round that is fired, that isn't the function of the trigger anymore. Got it.
Where an expert can take a regular semi-automatic rifle and hold it loosely enough that they can do something like bump firing. And I think in our view there too, there's just one function of the trigger, because the first push starts the sequence and then the sequence continues. The ATF explained, and we agree, that that's not automatic because there's no self-regulating mechanism. The user has to control the recoil.
So what's the difference? The same thing is happening with the trigger.
The same thing is happening with the trigger, and I think that's why we would say with manual bump firing, there is just a single function of the trigger. There's one action that initiates the firing sequence. We think it's not automatic because there's no self-regulating mechanism.
The government is arguing that a semi-automatic firearm with no modifications becomes a manual machine gun when bump firing, and that even though the weapon is unchanged, shooting that way is a single function of the trigger, in spite of the fact that it is obviously being pulled each time.
I just want to ask you about this bump firing thing. Mm-hmm. So what if I designed something and I call it a bump band? Because I gather you can do this with bands and you can do it with your belt loop. So what if I design and market something I call the bump band to help me turn my semi-automatic, in the same way? Why wouldn't that then be a machine gun under the statute?
So we think that's still not functioning automatically because that's not a self-regulating mechanism. My understanding is that what those devices do is they help the shooter keep their trigger finger still, but the shooter still has to manage the movement of the rifle back and forth.
So rubber bands are A-okay, and the ATF is not going to go after them. I am sure they won't change their mind.
These are the kind of weapons that Congress was intending to prohibit because of the damage they cause, or something like that. So I see Congress as putting function in this. The function of this trigger is to cause this kind of damage, 800 rounds a second or whatever.
Now that's a lot of damage!
So you see, the function is not about the operation, it's about what it's used for, which is the thing that operates by the user.
Our view is not that because Congress banned machine guns because they're dangerous, anything that's dangerous or that shoots fast is a machine gun. But we acknowledge this is not a rate of fire statute, it's a function statute.
Then why are we here?
This is an interpretive rule. The ATF doesn't have the power to make something a crime that wasn't a crime before. It's not a crime to violate the rule.
What did you say?
That's all they do with the rules that reinterpret clearly written single sentences in legislation and turn it into an 80-page essay on what is a receiver.
The ATF is saying we got that wrong before and we're fixing it now.
The funny thing about the ATF interpretive rules is that it is an acknowledgement that they were wrong about the meaning of a law. But now we can trust them. They totally got it this time. They understand it completely. Yeah, I'm sure.
Leads me to believe that at best there might be some ambiguity. Now the question is, what's the best reading?
Only our finest legal minds can take a sentence and parse out the hidden meaning that is evident on its face. That is so ambiguous. What does it mean?
It is possible to do bump firing, meaning that the rifle moves back and forth and bumps against your stationary finger. An expert can do that without any assistive device at all. And you can also do it if you have a lot of expertise by hooking your finger into a belt loop or using a rubber band or something else like that to hold your finger in place.
Okay, anecdotally, I have bump fired accidentally before. You don't have to be an expert. You can learn how to do it within a single range trip. And the gun control side of the Supreme Court is obviously pushing for something that the government is not even arguing. They make a big deal about the rate of fire being what makes it something that should be banned, but that's not the argument that's being made at all, and yet they are stuck on this, because you have people making these decisions who know nothing about the actual items.
The problem here we acknowledge is ATF used to say something different about these, but we think that's taken care of by the rulemaking and the doctrine of entrapment by itself.
Because people will sit down and read the Federal Register.
No, I think because people who have these devices...
That's what they do in their evening for fun. Gun owners across the country crack it open next to the fire and the dog.
I take that point.
Wait, what? Is that not what people do?
So the rate of a semi-automatic weapon is not a fixed number because it depends both on the weapon and very much on the skill of the shooter. I think the Giffords amicus brief says the theoretical maximum for a very skilled competition shooter with a specialized weapon is something like 180 bullets a minute. In practice, it's much, much slower than that for the vast majority of people who would use one of these things. A fully automatic weapon...
How much slower?
I think, it depends. I think more on the order of, 60, something like that. So when the ATF first looks at these, it's the Aikens accelerator in 2002. That's the bump stock with a spring in the back where you don't even have to push forward. And initially, ATF tests it, the prototype breaks, but the ATF writes a classification letter, which is something relatively informal, just goes to the manufacturer, doesn't contain a lot of legal reasoning, says this isn't a machine gun because it doesn't have multiple functions of the trigger. Very quickly thereafter, ATF corrects that error, and in 2006 says the Aikens accelerator is a machine gun because it does shoot multiple shots by a single function of the trigger. So that part we've been consistent on.
And yet the public is at the mercy of these letters. These letters greatly influence entire sectors of the gun industry, including people investing life savings into products, but then you keep mucking with the laws and changing your mind via rules after the fact.
It seems to me that through its use of the word function, Congress was trying to capture a class of weapons in which a trigger is used once to achieve a certain result, which says in the statute automatic firing many times. Sure. And so weapons with bump stocks have triggers that function in the same way. Through a single,
Wrong.
pull of the trigger or touch of the trigger, you achieve the same result of automatic fire of the weapon. So why is that inconsistent with grammar or the way the statute reads?
Well, the premise of Your Honor's question is not true. A single discharge of the trigger produces only one shot. It doesn't produce a round of automatic fire.
Hold it backwards and automatic fire happens, but we push it forward and automatic fire happens. Congress says no.
There's no automatic fire. I'm sorry, Justice Jackson. There is no automatic fire that starts a motor.
Now I'm completely lost. The trigger is not doing anything. It's the person doing something. And it's the person choosing on an M16 whether they're going to keep the switch on semi-automatic or put the switch on automatic and turn the M16 into a machine gun.
If an M16 is able to fire automatically, it is always a machine gun. Should probably be aware of that, being on the Supreme Court and all.
Mr. Mitchell, I'll tell you, I view myself as a good textualist.
I thought it was a joke! I even wrote it down in my diary!
And here she goes off just this weird tangent and doesn't get off of it for several minutes.
So why couldn't we read the words function of the trigger in this statute to mean the function of the trigger is to start a chemical reaction that leads to the expulsion of a projectile? When we put those together, the work of the function of the trigger, I think, could be to start the chemical reaction that then results in the automatic more than one shot coming out of the gun. Why can't I interpret it that way?
Vaughn into the windup in his first offering. Just a bit outside. He tried the corner and missed.
Okay, that's a function of their cartridge, and even if that is what you counted, it still would occur each time the trigger is pulled on a bump stock weapon. And that's it for the highlights. I wanted to include a bit from each side and kind of go over how ridiculous the whole thing is. What are your thoughts on the case? Do you expect them to come back in favor of the government, or will the bump stock ban be eliminated? Let me know in the comments below if you have made it to the end of the video. Please consider supporting me on Patreon, joining the Discord, subscribing to the channel, liking the video, and sharing it with others. Thanks for watching.